Hello, I'm Susan Schoenfeld, Senior Legal Editor for BLR's Human Resources and Employment Law publications, and I'm here today to talk about medical certification under the Family and Medical Leave Act, or FMLA. Now, we receive a number of FMLA medical certification questions through our Ask the Expert service. Here, we'll provide a quick review of FMLA's medical certification rules and answer one of the most frequently asked questions on medical certification. FMLA allows employers to request medical certification for the employee's own serious health condition, or the serious health condition of a covered family member, or for the serious health condition of a covered service member. If an employer is going to require medical certifications under FMLA, it is also required to provide the employee with written notice of such a requirement and the consequences of failing to provide requested medical certification. This notice may be given in the form of the Department of Labor's Notice of Eligibility and Rights and Responsibilities form, more commonly known as the Form WH-381, or an employer may use a similar document that it creates on its own, but more about that later. Now, there are very specific rules regarding the timing of FMLA medical certification. In most cases, requests for medical certification of the need for FMLA leave should be made immediately after the employee gives notice of the need for leave, or at the latest within 5 business days afterwards. Or, in cases of unforeseen leave, the employer has 5 business days after the leave commences to provide the notice of the need for medical certification. The employee also has responsibilities under FMLA. Employees must provide the requested medical certification, or in some cases recertification, within 15 calendar days after the employer's request. This is true unless it is not practicable under the circumstances to provide such certification, despite the employee's diligent, good faith efforts to do so. Or, in some cases, unless the employer actually allows more than the 15 calendar days to return medical certification under FMLA. Now, as I mentioned before, an employer can utilize the Department of Labor's certification forms designed for the purpose of FMLA medical certification, or the employer may use its own form, so long as that form does not violate the regulatory requirements, such as requiring additional information beyond that which is required by the DOL on its own forms. This all sounds simple, right? Well, judging by the number of questions we receive from BLR subscribers on the topic of medical certification, certification is far from simple. To illustrate some of the more common pitfalls of medical certification under FMLA, we thought we'd share some real customer questions and our answers to them. This is the first in a short series of videos that answers some of the tough questions we've received from HR managers. Today we're going to address a question that arises pretty frequently. Do I really have to get medical certification? What if the need for FMLA leave is so obvious that requiring medical certification seems unnecessary? Employers often ask what to do when they know, or it is so obvious that an employee is hospitalized or otherwise incapacitated, and obtaining the proper FMLA medical certification seems unnecessary, or will just take too long. In one case, an HR professional asked us, "Can I approve FMLA just by knowing that an employee had surgery and is hospitalized?" Well, the strict interpretation answer to this question is what you might expect. As with any employment practice, selective decisions as to when to require a medical certification and when to forego such a requirement are subject to challenge under applicable EEO laws, and it may be advisable to avoid all such claims simply by requiring a medical certification in all cases, even if the need for leave in some cases is self-evident, or obtaining certification may be time-consuming. Getting certification every time for every employee ensures that the employer's leave practices will not be challenged as selective or discriminatory. Remember, the employer can always conditionally approve FMLA leave pending the receipt of medical certification. And this way, employees who have an immediate need for leave aren't denied leave or leave benefits such as substitution of paid leave. while they're waiting for the doctors to provide medical certification. Now, the answer I just gave you assumes that the employee actually provides medical certification eventually. But what about the situation when an employee refuses or fails to return medical certification? In the next video in this series, I'm going to answer a recent question involving this scenario, which I call the no-show certification. HR.blr.com's Ask the Expert service is an exclusive benefit for our subscribers. To learn more about becoming a subscriber, please visit hr.blr.com. Thank you.